Switch phones off, of course. Right, I welcome members to the 19th meeting in 2013 of the Delegated Powers and Law Reform Committee, noting, of course, that this is the first time we've met under this new name. Can I ask members to switch off their mobile phones, please? We have apologies from John Pentland. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes item 6 in private. This is consideration of a draft report on the delegated powers contained in the Landfill-Tax-Scotland-Bill at stage 1. Do members agree to take that item in private, please?
Agree.
We do. Thank you very much. Which brings us to agenda item 2, instruments subject to affirmative procedure. The registration of social workers and social service workers in care services Scotland Regulation 2013 draft. Regulation 9.1 continues the application of the requirements in Regulations 4 to 6 of the Regulation of Care, Fitness of Employees in Relation to Care Services Scotland No. 2 Regulations 2009 for social workers and social service workers to achieve registration with the Scottish Social Services Council within the period as provided for in those regulations to workers who started work prior to the coming into force of these regulations on the 1st of August 2013. Regulation 9.2 provides that an application for registration under those provisions of the 2009 regulations made by those workers and not determined by the 1st of August 2013 is to be treated as an application for the registration under these regulations. Regulations 4 to 7 of these regulations contain some differences in the application for registration requirements, including as to the exemptions from registration which apply. So confusion could be caused by the two incompatible directions, the direction that Regulations 4 to 6 of the 2009 regulations continue to have effect, and the direction that an application under these provisions is to be treated as an application under the provisions of these regulations. Does the committee agree to draw the regulations to the attention of the Parliament on reporting ground H, as the meaning of Regulation 9 could be clearer?
Agree.
Thank you. Agenda item 3, instruments subject to negative procedure. The Water Environment Controlled Activities Scotland Amendment Regulations 2013, SSI 2013-176. Rule 13H4 should have been listed as Rule 13.1. So the removal of accumulations of sediment from rivers, etc., permitted by that rule is only authorised if every aspect of that activity listed does not result in pollution of the water environment. As currently drafted, the prohibition on pollution of the water environment only applies as a condition of the return of the removed sediment to the river, etc., from which it was removed. The committee may wish to note that the Scottish Government has undertaken to correct this error when the controlled activity regulations are next amended. John.
If I may, just for the record, when you said Rule 13H4 should have been listed as Rule 13.1, did you in fact mean Rule 13I?
I did. Well spotted, sir. Thank you.
I'm not wishing to be nitpicking, but just for the avoidance of doubt.
I'm very grateful that you are picking, and I think it demonstrates just how careful folk in this committee are. I'm extremely grateful. I'm sure the official report would have got it right nonetheless, but does the committee agree to draw this instrument to the attention of the Parliament under the general reporting ground as it contains a minor drafting error?
Agree.
Good enough to trip even me up.
Can I just make an observation in passing, convener, that the confusion over I and 1 is a very understandable one, because sometimes an I in legislation means 1. If it is the sub-clause, then it is numeric, not alphabetic. And therefore, it is actually perhaps genuinely an issue which relates to the rules and structures by which drafting is done that can lead to this kind of misapprehension and error. And I see our lawyers are nodding, so I'm not missing the point on this.
Yeah, I think the point is very well made.
I mean, I just want to agree with that. I totally agree with that does cause confusion, and that there is a legal point, and I accept what is being said.
I think we've made it very eloquently.
Indeed. I'm very grateful.
Right.
Yes.
Indeed. Does the committee also agree to note that the Scottish Government has undertaken to correct this error when the controlled activities regulations are next amended, but probably retaining Roman numerals?
Yes.
No points have been raised by our legal advisers on the Glasgow Commonwealth Games Compensation for Enforcement Action Scotland Regulations 2013, SSI 2013-160. However, although no formal points have been raised by our legal advisers, the committee may wish to highlight a couple of issues to the lead committee. The regulations are to cease have effect on the repeal day, which ministers being empowered to specify any day after the Games have ended as the repeal day. The regulations contain no provision as to how an ongoing compensation claim, or one which could still be made within the period set out at Regulation 4, is to be dealt with. The Scottish Government has indicated that any ongoing claims would be taken into account in determining the repeal day, and that consideration would be given as to whether any future legislative provision would be required to deal with unresolved claims. However, the committee may wish to highlight this issue to the lead committee. Regulation 4.2a and b specify the deadlines within which a notice of claim must be sent. It appears from Regulation 4.2 and also Regulation 4.4b that identification and provision of the date on which the damage occurred is, in all cases, an essential requirement. Provision is not made for what is to happen when the date on which the damage occurred is not identifiable and cannot be provided. This is, of course, a policy issue which the committee may wish to highlight to the lead committee. Does the Hansela?
There are a number of issues with that. One is that it's not always possible to give an exact date. I can give you an example of, for example, if someone was to lose an item and they went to report it to the police, and they would normally say it was either lost or stolen, and when it came to a date, they would say it was between this date and that date, which means, you know, there is an example in law where people can't give an exact date. And the other issue, of course, is that sometimes there may be claims made after a claim's been made as well. Mm-hmm. And I'm not sure how clear that provision is in the current. Maybe the policy committee could look at that as well.
Indeed. Does the committee agree to draw the matters raised in relation to the Glasgow Commonwealth Games Compensation for Enforcement Action Scotland Regulations 2013, SSI 2013-160, to the attention of the lead committee, whilst not reporting the instrument formally?
Agree.
We do. Thank you. No points have been raised by our legal advisers on the Town and Country Planning Appeal Scotland Regulations 2013, SSI 2013-156, nor on the Town and Country Planning Schemes of Delegation and Local Review Procedure Scotland Regulations 2013, SSI 2013-157, nor on the National Health Service Superannuation Scheme and Pension Scheme Scotland Amendment No. 2 Regulations 2013, SSI 2013-168, nor on the Equality Act 2010, Specification of Public Authorities, Scotland Order 2013, SSI 2013-170, nor on the Animal Health Miscellaneous Amendments, Scotland Order 2013, SSI 2013-173. Is the committee content with these instruments, please?
Content.
Thank you. No points have been raised by our legal advisers on the National Health Service Superannuation Scheme 2008 section, Scotland Regulations 2013, SSI 2013-174. However, the committee may wish to note that this instrument consolidates the provision of the National Health Service Pension Scheme, Scotland Regulations 2008. And it would perhaps be appropriate to be grateful that we have seen a bit of consolidation. Thank you. Is the committee content with this instrument?
Agree.
Okay. No points have been raised by our legal advisers on the requirements for Community Learning and Development Scotland Regulations 2013, SSI 2013-175, nor on the Dangerous Dogs Fees Scotland Order 2013, SSI 2013-178, nor the Annisland College and Langside College Transfer Enclosure Scotland Order 2013, SSI 2013-180, nor the Kilmarnock College Transfer Enclosure Scotland Order 2013, SSI 2013-182, nor the Reed Kerr College Transfer Enclosure Scotland Order 2013, SSI 2013-183, nor the Police Reform Pensions Amendment Scotland Regulations 2013, SSI 2013-184, nor the Fireman's Pension Scheme Amendment Scotland No. 2 Order 2013, SSI 2013-185, nor the Fire Reform Pensions Amendments Scotland Order 2013, SSI 2013-186, nor the Plant Health Scotland Amendment number 2, Order 2013 SSI 2013-187, nor the Mobile Homes Written Statement Scotland Regulations 2013 SSI 2013-188, nor lastly on the National Health Service Free Prescriptions and Charges for Drugs and Appliances Scotland Amendment Regulations 2013 SSI 2013-191. Is the committee content with these instruments, please?
Content.
Thank you. Which brings us to agenda item 4, instruments not subject to any parliamentary procedure. The Acts of Sederent Rules of the Court of Session Amendment number 4, miscellaneous 2013 SSI 2013-162. Paragraph 7 saves the rules of Court of Session as they are applied prior to the 24th of June 2013 for the purposes of appeals under Section 51 of the Children Scotland Act 1995, appeals relating to children's hearings, which are commenced but not determined before the 24th of June 2013. It also saves those rules in relation to any further rights of appeal which follow on from such appeals. It is not clear from the drafting of paragraph 7 whether the saving is intended to apply only to appeals to the Court of Session which are made before an appeal to the Sheriff or Sheriff Principal under Section 51 before the 24th of June, or whether it is also intended to apply to appeals to the Court of Session which are made from an application to the Sheriff or Sheriff Principal under Section 51 before that date. The drafting could accordingly be clearer in giving effect to that intention. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground H, as the meaning of paragraph 7 of the instrument could be clearer?
Agreed.
Thank you. No points have been raised by our legal advisers on the Acts of Sederent. Sheriff Court Rules Miscellaneous Amendments number 3, 2013, SSI 2013-171. However, the committee may wish to note that the convention regarding laying instruments 10 to 14 days prior to the first coming into force date has not been observed in relation to this instrument. The result is that the committee has not had the opportunity to scrutinise the instrument prior to the first coming into force date. Is the committee content with this instrument, please?
Content.
No points have been raised by our legal advisers on the Act of Sederent, Children's Hearings Scotland Act 2011, Miscellaneous Amendments 2013, SSI 2013-172, nor on the Children's Hearings Scotland Act 2011, Commencement number 8, Order 2013, SSI 2013-190. Is the committee content with these instruments?
Content.
Thank you. Agenda item 5. This is the Victims and Witnesses Scotland Bill. This item of business is consideration of the Scottish Government's response to the committee's Stage 1 report on the Victims and Witnesses Scotland Bill. Members will have seen the briefing paper and the response from the Scottish Government. Do members have any comments, please? No? Are we content to note the response and, if necessary, reconsider the bill at Stage 2?
Agreed.
We are. Thank you very much. That brings us to agenda item 6, which we take in private. Thank you very much.